Good morning, everyone. We're going to wait for just a minute. We're having some technical issues getting the Zoom link to work, so I want to wait just a minute so my staff can get that running.
Hey, Alan, the YouTube's all set and ready to go.
Okay. And if anybody has a colleague or a friend or other person they know who's trying to watch on the Zoom meeting, they may have to refresh their Zoom link, their YouTube link. The problem we're having is that for some reason we're still trying to fix. We get the name of the next proceeding pops up on the YouTube. So then we change the name to the current proceeding and people have to refresh. But it looks like we're ready to go. So we'll go ahead and get started. Today is February 2nd, 2022. I am Alan Lilly, presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. And this is a continuation of the hearing on the prosecution team's draft cease and desist order, which was issued against BlueTriton Brands, Inc., which I normally refer to as BlueTriton. Everyone has previously appeared, so I'm not going to ask for appearances again. The appearances, their names all do show up on the Zoom recording transcript as well. I believe where we left off yesterday afternoon is that Story of Stuff Project had offered its exhibits, most of its exhibits into evidence. We had rulings on several of them, and I think there was just one exhibit left that we did not resolve the offer of admissibility or admission into evidence, and that's exhibit SOS 31, which was the declaration of Steve Lowe. And my notes indicate that BlueTriton objected to paragraphs 30 to 32, 40
Mr.
to
Lilly,
40.
Mr. Lilly, excuse me, my hand is up.
Oh, okay, go ahead. I'm sorry, Mr. Donlan, I was reading my notes, so I got the right paragraph numbers, so I did
Well,
not
I
see
just
it.
very briefly, before we get going today, I'd like to state for the record my objection to the fact that you continued the hearing for nearly 30 minutes past 2:30 yesterday afternoon. That was incredibly inappropriate and prejudicial to my client.
All right, Mr. Donlan. First of all, I do not think it was 30 minutes, but the record can see how long it was. Secondly, the only matter that we covered after 2:30 when you signed off was the completion of the objections from BlueTriton to Story of Stuff Project's exhibits, which I'm trying to remember, Ms. Grady of your office was handling anyway, and in all appearances was handling very competently, and did have the assistance with two other attorneys from BlueTriton, Mr. Sanders and Ms. McGuire, who were still participating. And I thought it was appropriate to complete that. And then when Ms. Grady said that she wanted to have more time to confer with you to talk about the admissibility of Exhibit 31, SOS 31, I then terminated the hearing. So I do not believe there was any prejudice to your client from the process I followed. And to the extent you stated an objection, the objection is overruled. And I will note that at Ms. Grady's request, I did basically terminate the hearing yesterday and said that we would start today with the objection, basically continue the objections to Exhibit SOS 31. Now, with that background, is there any specific objection you have to the process I followed yesterday?
Well, respectfully, Mr. Lilly, I asked you on Monday if we could terminate the hearing at 2:30 yesterday for the very reason that my client wanted me to participate and I was unable to do so after 2:30. You agreed with that and you said so. It is not your position to tell my client who should represent them at a hearing. Respectfully, I know I have competent co-counsel on this. So does my client, but that's their decision. I'll let it go there, Mr. Lilly. I just wanted to state that for the record.
All right. My question was, can you identify any specific prejudice to BlueTriton that occurred when I followed the process I just described?
They were denied the opportunity to have the counsel that they wanted at the hearing at the hearing.
All right. I'm not hearing any specific prejudice, so we will leave it at that. And if you believe, Mr. Donlin, that you now need to state any further objections to any of the Story of Stuff Project's exhibits, you may do so. But let's first finish up with Ms. Grady's objections to SOS 31, and then we can circle back. If you have any other objections to any of the exhibits, you may do so. Normally, I only allow one attorney per party to state objections, just from a matter of efficiency's point of view, and Ms. Grady had been stating all the objections to the Story of Stuff Project witnesses, but I will allow you that after we finish up with Ms. Grady. So, as I said, I think my notes indicate that Ms. Grady objected to paragraphs 30 to 32, 40 to 43, and 53 to 55 of Mr. Lowe's declaration on the grounds of relevance, that they did not pertain to the hearing issues. Basically, they concerned public trust issues, which I specifically ruled in my prior ruling would not be considered during this hearing. Do I have the paragraph numbers and basically the characterization of your objection correct, Ms. Grady?
Yes.
All right. And I guess before I rule, I will ask Ms. Doty, do you have any response to that objection, to those objections to those paragraphs?
I do.
What is that? Please go ahead.
Each of the paragraphs provides evidence of where the water was prior to BlueTriton's diversions in the 1930s. So it tells you what species the stream was able to sustain, tells you the nature and the permanence of the water in the stream. So if you have certain kinds of fish, it means you need pools and riffles, and you need the ability of a continuous stream flow to repopulate those areas after significant flooding. So my understanding from your prior ruling is that Mr. Lowe would be able to testify to those issues. And again, we did remove testimony that was public trust, straight up public trust related, but it can't be that we can't talk about the flora and fauna that indicates the nature and location of the water, because all of that is evidence of what the water is. We have BlueTriton arguing that this was all below ground water before 1930. And if it was all below ground water before 1930, you wouldn't have had fish in the stream. And that's what Mr. Lowe's testimony boils down to, is where fish and riparian habitat existed and when.
Mr. Lilly, I think your screen may be frozen.
All right, so I don't know what happened, but I just got out and then back in. It looks like Miss Grady is still frozen, which concerns me. Oh, wait, there. Miss Grady, are you now back? Can you go off mute?
You were the only one that seemed to be frozen from my perspective, and then you
Oh,
disappeared.
okay. All right, well, I'm not sure what happened, but you're now back, which is good. Did you hear Ms. Doty's response to your objection?
I did.
And my question to you was, your hand was up and then it went down. Do you have something you want to say before I rule?
Well, I just wanted to clarify that again, Ms. Doty is speaking of the testimony provided by Mr. Lowe. As if it's factual statements, it's his opinion that he proffered.
All right, so here's how I'm going to rule. I think the objection is valid as to some, but not all of the paragraphs. Paragraphs 30 and 31, I'm going to allow into evidence with the other parts of Mr. Lowe's declaration exhibit SOS 31 that I'm allowing into evidence. I think they, while they're talking about riparian vegetation and ecosystem, there are evidence regarding the hydrology of the amounts of water in the creek. On the other hand, I am not going to admit paragraph 32. I think it really solely relates to fish and wildlife habitat rather than to hydrology. So 32 is not admitted. Regarding paragraph 40, I'm going to admit paragraph 40 into evidence because, again, I believe it's at least somewhat relevant to the question of historical hydrology. I'm going to not admit paragraphs 41, 42, and 41 and 42, because again, I believe those are simply public trust issues, primarily fisheries is what those paragraphs pertain to, rather than hydrology. So they go beyond the scope of the hearing issues. I'm going to allow paragraph 43. Again, I believe the discussion of alders, it's basically the condition of alders as evidence of the historical hydrology. And I'm not going to allow into admission paragraphs 53, 54, and 55 because they appear to solely relate to what we're calling public trust values, basically biological resources, and do not have evidence of the hydrology. So that is my ruling on those paragraphs. And with that, the rest, so the bottom line is SOS 31 is admitted into evidence with the exception of paragraphs 32, 41, excuse me, make sure I get this right, 41 and 42, and 53, 54, and 55, which are not admitted into evidence. So with that, Ms. Brady, I think that was your last objection to the Story of Stuff Projects exhibit, but just to make sure I'm thorough, do you have any other objections to Story of Stuff Projects exhibits that we have not already addressed?
Not that you have not already addressed. Thank you.
All right, and Mr. Donlin, I did say, based in response to your prior comments, I'd give you a chance to respond. Do you have any additional objections to any of the Story of Stuff Project exhibits other than those we've already addressed? And I'm pretty sure I ruled on all of the Ms. Grady's prior objections before you left at 2:30 yesterday afternoon.
I do not have anything further, Mr. Lilly.
All right, thank you. All right, we now are ready to move on. Oh, excuse me, but I believe, Ms. Doty, that completes your case in chief. Have I missed anything?
But just so with regard, are the other exhibits then admitted other than the ones that were specifically addressed?
That is correct. Thank you for that clarification. So the other than the rulings today and yesterday, Story of Stuff Projects exhibits 1 through 264, and it was not continuous, but the ones that are in our exhibit list are admitted.
Thank you, and that's the end of our case in chief.
All right, we will now proceed with Mr. Lowe's independent case. Mr. Lowe, I see your ceiling. There you are. Good morning. As I mentioned yesterday, I have read over your declaration, which we have labeled, let me make sure I have this right. I believe we've labeled that as Low 1. Let me just double check and make sure I have the right labeling of that. If I can get there. I'm having a little problem with my computer getting to the exhibits. Let me just try here, see if I can get there. I can't. Mr. Anderson, can you just tell me, is Mr. Lowe's declaration at SOS 1?
Give me 10 seconds.
Yeah.
Yes, it is.
All right. So, Mr. Lowe, first of all, you are still under
Mr.
oath.
Lilly, I apologize.
Wait a minute, I
real-
see Ms. Grady's hand is up.
I raised my hand only because you just said SOS 1, and I believe that you meant low 1.
Thank you, Mr. Sanders. That is correct. We will call this exhibit low 1. I'm sorry, I mean, we have called it that. All right, thank you, Mr. Sanders. So Ms. Grady, your hand is up. What is your question or comment?
Thank you. We did have objections to Mr. Lowe's personal testimony as well. And I want to clarify for the record that we had objected on the basis that he is not identified in his individual capacity as an expert. Much of this testimony is opinion. I don't know that it's proffered as, well, some of it I think would be characterized as an attempt to proffer expert testimony. Much of it is conjecture and unfounded allegations as to illegal conduct and things of that nature that are wildly improper. So we object on those grounds as well.
All right, let's
To the extent,
go ahead. Excuse me.
go ahead. I apologize. Go ahead.
No, does that complete your objection?
It does.
All right. So what I'm going to do is, first of all, have Mr. Lowe offer this into basically authenticate this as his testimony, and then I will give him a chance to summarize it. As far as your objection goes, Ms. Grady, I've previously ruled that Mr. Lowe may state opinions based on his extensive personal knowledge of the relevant facts, and I believe that that opinion, to the extent that he is stating opinions, that's generally admissible under Government Code Section 11513, Subdivision C. If we get to after he has, assuming he authenticates this as his written testimony, as his written proposed testimony, let me try that again. Assuming he authenticates Low 1 as his testimony for this hearing, then I'm going to give him an opportunity to summarize that. And then when he offers it into evidence, if you want to object to specific paragraphs on other basis, then you may do so. So let's proceed that way. So Mr. Lowe, you previously took the oath and you are still under oath for this hearing. Is your declaration of Steve Lowe in support of Water Board for BlueTriton hearing, which we've labeled as Exhibit Low 1, and this is separate from the declaration you submitted, or Ms. Doty submitted, for the Story of Stuff project that you gave. But is Exhibit Low 1 your testimony for this hearing?
Yes, it is.
All right. And again, I mentioned to you yesterday, I'm going to give you an opportunity to summarize this, but summary really does have to be, I'm summarizing certain paragraphs, not a whole new written statement. So, and you don't have to give a summary. The exhibit is now in, I have read it, and it is into evidence. So do you want to give any summary of this exhibit?
I'd like to give an opening statement, if I could.
Oh, okay. And I'm sorry I forgot that. I got a little ahead of myself here. So, all right. So we'll make sure the record is clear on this. You may give an opening statement for up to 5 minutes. The opening statement is not testimony, but it's effectively your argument about and your description about what is in your testimony. So you can have 5 minutes for that. Why don't you go ahead and do that? Please go ahead.
And then can I go ahead and get maybe another 5 minutes for my testimony, my real testimony, where I'm under oath and what I say is important?
Yeah, well, it's all important, but yes, you may have another 5 minutes to summarize your written proposed testimony. So, but we will make sure that the record is clear that those are two different things here. So you are now proceeding with your opening statement, which is not under oath and will not be admitted into evidence in this proceedings. Please go ahead. I have 11:22, and I will give you 5 minutes for an opening statement.
Okay, thank you, Mr. Lilly. I wanted to thank you for trying so hard to let the public participate. I know it's hard on you guys, and you can't believe how hard it is on us to go through this. It's a real challenge for me. But thank you so much, and thank you for listening so well. I would really like to thank you for listening so well and reading to be ready and trying to understand where people are coming from. You've done a wonderful job there. I'd like to thank those that have contributed in getting the truth out in the open. One of the things that's been so frustrating to me over the years is how hidden all of this has been. And I just want to be honest, and that's what we're doing here, and I'm really happy about that. I'd like to thank the BT lawyers for being respectful to me and to the other members of the public that have been trying to be involved. We know that all these Headwater Strawberry Springs were perennial springs that flowed to the surface and contributed to the tributaries that eventually flowed into Strawberry Creek. We know that the stream was much more lush than it is now. We know that there was many more alders. The riparian vegetation was more extensive. We know that the stream had more expressions of.
Excuse me, Mr. Lowe, I don't know what happened, but your camera now shows a piece of paper and not your face. So
I'm sorry, I was reading, so, okay.
Try to
I'm sorry.
have it so the paper does not block the camera's view of you. Please proceed.
Okay, thank you. So like I said, we know the stream was much more lush, had considerably more riparian habitat, had more surface expression of water, actually had more springs at that time. I believe that dewatering of the aquifer has resulted in the loss of some additional springs, even besides the ones that were developed. We now realize more water is actually taken from the stream than is needed by BlueTriton, which was so depressing to me. And until recently, that water wasn't put back in until all the way at the bottom of the stream, basically dewatering 4 miles of stream. That was hard on me. And now we know that they're dumping it about a half a mile downstream. So we're dewatering a half a mile of stream. We've also seen that that was part of their intent originally, was to dewater the upper creek to get rid of the alders so that they could say they were salvaging the water that those alders would have used. So just today, I checked the USGS gauge in East Twin Creek, which I check often. East Twin Creek measures East Twin Creek, Strawberry Creek, and Coldwater Canyon. This morning, the Twin Creek gauge registered the lowest level ever recorded in 100 years. It is currently at 0.57 CFS, and that's the lowest ever recorded. Previous low was 0.76 CFS. This is winter. The thing ought to be flowing 3, 4, 5 CFS, and the median for the last 100 years is 3.4 CFS. So if you take the 150 gallons per minute, that's the minimum. It's actually 160, I believe, minimum that should be flowing from the springs that are developed by BlueTriton. If you take that 160 gallons per minute, that's about 0.36 CFS. So that's about 2/3 of what's currently flowing in the combined Strawberry Creek. So it would be very, very, very important to Strawberry Creek to have that 0.36 CFS. And it actually makes a difference in survival of many species of animals. So that's where I'm at. And that's why I'm just so glad that we're going to finally get all of this out in the open and be honest about it, and hopefully get some water back in the creek. Thank you.
All right, thank you, Mr. Lowe. That will be your opening statement. And as I noted, it basically, we will treat that the same as the various policy statements that parties have submitted. It's not evidentiary, but it is something that the board considers as a statement of a party. So with that, we are now up to 11:27. So now would you like to give a summary of your written proposed testimony, which has now been accepted as your testimony? Would you like to give a summary of that? And this will be under oath. And incidentally, subject to objections and cross-examination.
Yes, I would just like to say that basically all the things that I said in there are correct, I believe. I've even been more convinced after looking at everything and listening to all the testimony that we've heard that there should even be more water in the creek than I thought there was originally. I've also seen that without a doubt, all of these springs, like I said in here, did flow to the stream. That's beyond a shadow of a doubt now. I've also seen that the amounts of water that should be getting to the stream is a lot of water. I knew there was some, but I didn't realize how much. It's a lot of water. I've learned from this how totally diverted these springs are. And I've got some pretty good ideas about how much water should be in there, but I didn't include it in my proposal. And since you asked me not to talk about things that I didn't include in there, I'm not gonna, I guess, mention that.
Yeah, please just stick to summarizing what's in your written declaration.
Right, that's what I'm trying to do. Okay, so in my written declaration, I talked about the drought. This morning, the USGS gauge in East Twin Creek.
Objection.
What's your objection, Ms. Grady?
We're going beyond the scope of the written testimony if we're discussing this morning.
Yeah, the objection is sustained. Mr. Lowe, I'm sorry, but you do have to stick to summarizing your written testimony. And obviously, I mean, since you submitted your written testimony back in December, I know it did not include conditions in the creek today. So that's beyond the scope of what you may summarize. So please proceed, but stick to summarizing your written testimony.
May I ask a question?
Yes.
I'm not sure how current conditions that are so extreme can't be part of what you're considering here. When I worked at the Forest Service, if we had new information, like we were in the worst drought ever, that you wouldn't not include that as evidence. I don't get it.
Okay, and I understand that this is confusing. I hope it's not so confusing that you've disappeared from the camera, though. Please,
No,
Chief,
I'm just
come
saying.
back. All right. I understand what you said about how the Forest Service operated, but when we run a hearing, we do have to follow specific procedures, and the procedures do require us, in this case, to have parties submit their exhibits in advance and then summarize testimony. Now, later on this morning, we will talk about rebuttal, and it's potentially could be relevant that this could be something that you could offer or Ms. Doty could offer as rebuttal evidence. But we do have to stick to our rules here. And this one I'm pretty rigorous about, because in fairness to the other parties, they have seen your written proposed testimony, and today all you may do is summarize that. That's just the process rules that we're following for this hearing.
Okay, thank you. That completes my case, I guess.
All right. Does anybody have any cross-examination questions for Mr. Lowe? Mr. Petrozelli, I see your hand is up. I don't. Oh, wait, Ms. Belenky, your hand is up. Anybody else? All right, Mr. Petrozelli, why don't you start with your cross-examination? Please proceed.
Thank you. Mr. Lowe, I wanted to ask you about your declaration, Low 1. So if we could put it on the screen, please.
All right, we will post exhibit Low 1. And please tell us what page number you want to go to or paragraph number.
Page 4.
All right. The pages aren't numbered. I'm numbering them on my paper copy now. Page 4 starts with carryover text, and then there we go, has paragraph 7 in the third line. Please proceed.
Yeah, so, and then if we can go down to paragraph 8 and the 4th line from the bottom. Okay, and Mr. Lowe, I'd like you to read this sentence on the right side of the 4th line from the bottom, starting in the 1980s. I'll read it with you. We only need to, but I'll read it with you. In the 1980s and 1990s, BT predecessors asked to develop additional boreholes to the east of the Spring 7 complex and make upgrades to the extraction and transport system. Have you read that?
Yes.
Okay. Were you involved in responding to that request?
Yes, I was involved in discussions with the biologist that actually did the field work with Gary Ernie. Gary Ernie was the lead special use administrator, and we've talked about Gary Ernie during this proceeding. Gary Ernie, Debbie Hyde-Sato, and Steve Hall were Forest Service employees that all walked the creek and evaluated whether or not the Forest Service should entertain any additional development or improvement of existing transport facilities that could allow removal of more water.
So, and can you maybe be a little more specific about what BlueTriton was asking for when you say develop additional boreholes?
You know, that's as involved as I got, was that they wanted additional boreholes.
So you don't know how many boreholes?
No.
Okay. You wouldn't know if they wanted deeper boreholes?
What I know is that over the history of the project for BlueTriton's predecessors, they put all these boreholes in originally, and on 7 and I think on 12, 10, 11, and 12, even on 1A, 1, 8, all of those have had
Objection. Just to,
boreholes.
Wait. Stop, Mr. Lowe. Ms. Grady, please state your objection.
my objection is to the extent Mr. Lowe is being asked to testify about things he is guessing versus things he's testifying that he knows, because about halfway through that, he said, and I think these other ones. So I would ask that we are not asking witnesses to make assumptions.
I think I'm going to sustain the objection. Mr. Petrozelli, I think it would be good if you would restate the question in terms of asking Mr. Lowe what his understanding or knowledge is about the proposal to develop the additional boreholes. So it's specific to his knowledge and avoids him speculating about things. So please restate the question.
Thank you. Mr. Lowe, what is your knowledge or understanding of BlueTriton's request at that time to develop additional boreholes at Spring 7?
That's really all I know. I didn't get detailed into the discussion. I just knew that they were going out there to evaluate whether they could allow any additional expansion or improvement of the facilities to take more water. That's all I knew.
But you do know that it was for the purpose of taking more water.
Yes, yes. And that's why it was denied, because the groups that went out there in the field determined that there could not be any more water taken and maintain the function of the stream.
Do you recall if BlueTriton's water right claims were considered in the approval process?
And Mr. Petroselli, I'm going to ask you to just restate that question to make it clear which approval. I'm assuming you mean the Forest Service process, but that was not clear. So
Yeah.
could you please
Okay.
restate it so we're clear as to what agency you're talking about?
Yes. So, Mr. Lowe, with regard to this request in the 1980s and 1990s to expand the Spring 7 boreholes, were the respondents' water right claims considered by the Forest Service?
The Forest Service has always officially recognized BlueTriton's claim to state water rights. And the Forest Service never challenged that with the state, even though many staff had considerable concerns about that.
Hearsay.
That I was there.
Wait, Mr. Lowe, that's an objection. And I'm going to overrule the objection. I'm not sure it's offered for the truth of the matter asserted. And in any event, I think it's a collateral matter. So let me think this through. This is a little tricky. I guess I'm gonna sustain the objection and strike that testimony. That does seem to be hearsay of Mr. Lowe describing out of court statements by other Forest Service employees. It may at least somewhat be for the truth of the matter asserted. It's why it's being offered. So, Mr. Petroselli, I think you better move on.
Okay.
I mean, I'm not sure your question intended to get that, but that's what came out. So we will strike the hearsay part of that, the part of that answer that discussed hearsay. Go ahead.
And perhaps I can ask it a different way. Mr. Lowe, do you recall what water right claims BlueTriton made to the U.S. Forest Service to support its request to expand the Spring 7 boreholes?
Yes, it's basically been the same argument from the beginning, and that they had actually pre-National Forest rights, that they had pre-1914 states rights, that they had Del Rosa judgment, which gave them all the springs in Strawberry Canyon. And I'm so sad that the Forest Service didn't challenge that. And
Wait.
I'm sorry.
You're getting beyond an answer to his question. Why don't you stop there? And Mr. Petroselli, ask your next question.
Okay. Do you recall, you said they claimed, I think, pre-forest rights. Do you recall what rights they claimed predating the National Forest?
It was just that they had been collecting water from Strawberry Creek for since before the forest was established.
Okay. So, and I'd like to go back to asking you about their request to expand the Spring 7 boreholes.
Excuse me, it wasn't just the Spring 7 boreholes. It was actually upgrading facilities and expanding to the east of the Spring 7 borehole. To
What-
additional
All
springs.
right, all right, that's it, Mr. Lowe. Let's let Mr. Petrozelli ask his questions.
Okay,
And I do say, will note, Mr. Petrozelli, the sentence you read before talked about additional boreholes to the east, not, and then it says upgrades to the extraction and transport system. So you might want to split it up into
okay.
asking about those things separately. That would
Yeah.
avoid a compound question.
Quickly object one more time on the grounds that Mr. Lowe testified at the outset of this line that he was not directly involved in his.
Okay, and I sustained that objection, but directed Mr. Petrozelli to ask Mr. Lowe of his understanding and knowledge, which he seems to have some, although perhaps limited. So again, Mr. Petrozelli, if you're going to pursue this line of questioning, split it between additional boreholes and upgrades, and make sure to ask about Mr. Lowe's understanding or knowledge, so he's not speculating.
Mr. Lilly, can we ask him for a proffer of basis of his knowledge so that we can understand even why he believes this to be the case?
I think he's already testified he had some familiarity based on his work at the Forest Service. So I think he has established a foundation, although admittedly fairly limited. So, Mr. Petrozelli, you may proceed, but I think Ms. Grady is making an important point that Mr. Lowe's knowledge about these subjects is fairly limited.
Can I say something?
No, you may not. I'm sorry.
I'd like to just clarify, it's not clear in this record if Mr. Lowe's testimony on these issues is based on review of any particular documents, conversations with any particular people. They're just assertions about what somebody on behalf of BlueTriton Brands predecessors and interests may have represented to any unknown persons in any unknown fashion.
Okay, I'm going to overrule that objection. To the extent you want to pursue that, you may do that on cross-examination. If you want to get it, excuse me, let me just transfer. If you want to get into the extent of his knowledge or the lack of knowledge, you may do that on cross-examination. So, Mr. Petrozelli, please proceed.
Yeah, I was going to comment that, Mr. Lowe is, representing himself. So could we give him perhaps a little more latitude to explain why his testimony might be admissible over objections than we may other witnesses?
I think, Mr. Petrozelli, I'm going to turn that one back to you. That's up to you to phrase your questions in a way that avoids these concerns and these objections.
Okay. All right. Thank you.
May I ask a question? Just a real quick question, Mr. Lilly?
Yes, you may ask a process. If you have a question about the process, go ahead.
Okay. So I've been watching and trying to understand, and when somebody objects, then the other parties get to comment on that objection. It doesn't seem fair to me that someone can object to what I say, and then you make a determination without giving me to explain to counter their objection. I have real information to counter someone's objection. We shouldn't just accept people's objection without me getting at least a few sentences to say something, it seems. Thank you.
Okay, this is a challenge when a party is basically appearing like you are on behalf of yourself. I mean, normally you would have an attorney who could bring these points out. And the problem is, if I allow you to explain, you're going to end up testifying more, even though there's been an objection that I may have sustained. So
I'll try. I'll promise you. I promise not to do that. I'm not trying to do that.
All right. Well, let's go forward as best we can. I'm trying to wade through this to give you a right to participate as a hearing, but to certainly respect BlueTriton's rights to object if they think the questions are going beyond what's proper. So,
right,
Mr. Petrozelli, I think you can really help a lot here. You're obviously a qualified attorney, and you've heard Ms. Grady's objections. So try to frame your questions narrowly and specifically in ways that will avoid these objections. And then hopefully Mr. Lowe can just answer them narrowly and specifically.
Thank you. So, Mr. Lowe, in your understanding, in your role working at the U.S. Forest Service, responding to BlueTriton's requests in the 1980s and 1990s, with regard to the Spring 7 complex, was the original natural discharge of Spring 7 considered in responding to their request?
That's a good question. There was very little left of the original spring orifices or surface flow or anything by the time they were making these requests. There was no surface flows at all from these springs that I'm aware of.
Do you know if there was excuse
Go
me.
ahead.
Do you know if there was an attempt to determine what the natural unmodified discharge of Spring 7 would have been?
Not as part of that evaluation. That evaluation was looking at the creek to see if there was any potential to entertain any more development in the canyon, and the group determined there wasn't. Oh, I forgot to. I was closely involved in that decision, not on the main team that went out, but I was in charge of the entire forest as the forest biologist, and so they ran that decision through me, and I agreed with their recommendation.
Okay. Based on your understanding, do you have any estimates of what the natural unmodified Spring 7 discharge would have been?
Yeah, it should be at least 20 gallons per minute and probably more. And that was in the historical record and in the current studies that have been done to look at that. It's been up to 100 even. That Spring 7 complex actually has more fluctuation than any of the other springs. In the really good years, it flows really, really good. And in the bad years, it gets pretty low. So yeah, I would estimate 20 gallons per minute continuously and more in good years.
You said it has a pretty variable flow.
Very variable, the most
Okay.
variable of all of them.
Okay. And then I wanted to ask you about this request to develop additional boreholes to the east that you reference in that sentence. Based on your understanding working for the U.S. Forest Service at that time of their request, what were they asking to do in developing additional boreholes to the east?
Objection. I think we're going outside of the scope and we're seeking double hearsay and speculation.
Mr. Petrozelli, I'm not sure that this is hearsay or speculation, because I think Mr. Lowe does have personal knowledge about this, but I'm concerned about the lack of relevance of this. I mean, these were proposals to the Forest Service, not the State Water Board. And Mr. Lowe has testified that nothing was developed there. So what is the relevance of this line of questioning?
So it's relevant because they're asking to add new points of diversion. It's relevant because they're asking to take more water and potentially expand a claim. And it's relevant because it goes to the need to issue a cease and desist order to prevent further unauthorized diversion and threats of unauthorized diversion.
So I'm sorry, Mr. Petrozelli, but when you say they are asking for new points of diversion and to take more water and expand the claim, do you mean BlueTriton is asking for that now, or that BlueTriton's predecessors were asking for that in the 1980s and 1990s?
Well, their predecessors have asked for it.
Their predecessors asked for it in the 1980s and 1990s. And for whatever reason, and I don't know that it particularly matters, but apparently the Forest Service denied the request. So BlueTriton's predecessors did not develop that. And I don't think, correct me if I'm wrong, but I don't think there's any evidence in the record that BlueTriton is seeking to develop such additional boreholes now. So I'll give you one more chance, but I'm not seeing the relevance to our hearing issues here.
Okay.
Wait, so are you going to not pursue that line of questioning, Mr. Petrozelli?
Yeah, I don't think I need to pursue that line of questioning.
All right, so Ms. Grady, I'm not sure there's any need to object. He's not going to pursue this line of questioning.
Correct, thank you.
All right, so please proceed, Mr. Petrozelli.
So, Mr. Lowe, I wanted to go down to page 7 and paragraph 12.
All right, we'll scroll down to page 7 and scroll down to the bottom of the page to paragraph 12. Okay. Please proceed, Mr. Petrozelli.
Okay. And this first sentence, the taking of all the spring water and large amounts of groundwater is having a significant adverse effect on the proper functioning of the stream. Based on your experience working at the U.S. Forest Service and having reviewed the requests of BlueTriton's predecessors in the 80s and 90s that you describe in paragraph 8, can you estimate roughly how much flow would be in the stream but for BlueTriton's diversions?
I believe there would be 160 gallons a minute flowing from the springs that have been tapped. And that's at a minimum. That's like the row figure that he told his bosses 90 would be a figure that they could count on. I believe 160 gallons per minute is a figure that we could count on, at least making it down to the hotel diversion point. I believe that with the increased riparian shade, and we might lose some to transpiration, which would be wonderful if we had riparian, but I believe that 160 gallons per minute would contribute to flows all the way down to San Bernardino City and the settling basins.
Okay.
And
Wait, that's probably,
sorry.
I think you've answered his question. I don't really want you to go on beyond his question. So do you have something else to say that is specifically regarding that question? If not, I think it's best to let Mr. Petrozelli ask his next question.
Mr. Lowe, echoing your comment about the variability of, spring 7, would there also be some variability in that 160 gallons per minute?
Yes, that's the lowest value. There would be a lot of variation because the individual springs, for instance, I figure 100 to 150 gallons per minute at the spring 1 through 4 complex and 8, and then 20 to 40 gallons per minute at spring 7, and spring 10, 11, and 12, 67 gallons per minute plus or minus 20. So yeah, there'd be quite a bit of variability. The good years would be higher, the low years would be lower. Yeah.
Okay.
And some of them take several years. So it wouldn't just be the current year's rainfall, it would be the previous years. And most of our recharge here comes in. Okay.
All right, but
Okay.
probably best for Mr. Petrozelli to ask his next question.
Mr. Lowe, would it take several years to see potentially 160 gallons per minute or more in the stream?
Objection. Mr. Petrozelli is continuing to ask questions without defining what he's talking about. Location, the stream.
Yes, the objection is sustained on that basis, and also, Mr. Petrozelli, again, I'm not seeing the relevance here. Can you explain the relevance of this line of questioning?
Well, the relevance is that presumably if BlueTriton were not diverting water from the springs, there would be flow in Strawberry Creek.
Objection, that is the state's argument.
Well, wait.
That's why it's relevant.
Well,
So
wait. Let me back up. Okay, I still don't see how that's relevant to the hearing issues.
okay, and you
And
don't think it's relevant that there would be flow in a known and defined channel if the respondent were not diverting that flow?
Well, I'm going to paraphrase the hearing issues and you tell me which one it's relevant to. The hearing issues are, is BlueTriton conducting any unauthorized diversions of water? And if so, should the board issue a cease and desist order? And if so, what terms should be in the cease and desist order? So how is the amount of water that could potentially reappear in Strawberry Creek if BlueTriton's diversions were reduced or stopped relevant to any of those three hearing issues?
Well, it's relevant to whether there is a diversion from a known and defined channel under 1201 and 1202. It's relevant as to whether their modifications of the springs have added new water. It's relevant if they're diverting and using water subject to Division 2 of the Water Code. So it's relevant.
All right, I'm not sure I agree, but I will allow you to continue, considering we do have fairly broad rules on admissibility of evidence. But with that, I do think Ms. Grady's objection is valid. That it would be good. I think you need to specify, if you're asking Mr. Lowe what he thinks based on his knowledge flows would be at a certain point in the creek if BlueTriton were not diverting any water, I think you need to specify what point in the creek you're talking about.
Okay,
And
I'll do it.
Wait, Ms. Grady, please go ahead.
I have one other objection. Mr. Petrozelli is the attorney for the state that issued this draft cease and desist order and report of investigation. And it seems that instead of asking cross-examination questions to clarify or address in the direct, they're instead just using this as open exploration to question Mr. Lowe about his opinion of things when Mr. Lowe has been available. The state could have presented him as witness. The state has been in contact with him for, I believe, 7 years. This is just, it seems to be going far beyond the scope of what's appropriate cross-examination.
All right, in that objection, I'm going to overrule. I've ruled before that once we have a notice of hearing, the hearing issues govern the conduct of the hearing. And if witnesses are testifying at the hearing, attorneys for other parties may ask them questions. I'm not aware of any specific legal rule that prohibits what you might call, I think you said before, friendly cross-examination. So I'm going to allow the line of questioning as long as the questions are seeking information that's relevant to the hearing issues. So with that, Mr. Petrozelli, you may proceed.
Mr. Lowe, we would see, you said we would see at least 160 gallons per minute flowing from the streams, but for BlueTriton's diversions. I'm paraphrasing. I'm not trying to mischaracterize your testimony. I'm just trying to bring us back. Where would we see that flow?
The 150 gallons, 100 to 150 that we would see from the upper springs, 1, 2, 3, 4, and 8, that would flow at least past the conjunction, the confluence, which Roe talked about a lot, and our current studies are talking about as well. The adaptive management plan talks about that confluence. So there would be 100 to 150 right there. Then by the time that got down to the 10, 11, 12 complex, there should be a significant amount of that still in there, especially until the riparian recovers, because there's no riparian in there now. The riparian vegetation will start using some of that 150. So over time, that 150 that reaches the Cienega and 10, 11, 12, that amount would probably decline. But everything that's been done out there clearly points to the fact that at the Cienega at 10, 11, and 12, there would be 20 to 50, 60. At one point, there was even 67 gallons a minute coming from the 10, 11, 12 springs when they were let back into the creek. Then number 7, that would join there at the Cienega. That's where spring number 7's drainage comes out, is there. Of the 20 that's that comes out of, that should be coming out of number 7, of that 20, a fair amount should get to the creek, but I'm not sure how much. That drainage has almost no riparian now and almost no surface water at all. So if, as number 7 got more riparian habitat, part of that 20 would be used. So I'm not sure how much, maybe, who knows down there. So the 150 might decline to 125, and then it would be added to at the Cienega. So anyway, that's what would happen as best I can tell. And
all right. So that's, wait a second. What's your objection, Mr. Grady?
The testimony has gone far beyond the scope of the question, and there's no description of what, when, where is being discussed. The topics seem to keep changing with no description. And this is being proffered as evidence.
Okay, I'm going to sustain the objection. I think Mr. Lowe is just trying to state his entire composite opinion here, but Mr. Petrozelli, I asked you to kind of split it up into asking questions about specific locations. So I think you need to do that for any further questioning in this area.
Thank you. So, Mr. Lowe, I believe you indicated that if the upper springs were allowed to flow, we would see flow in Strawberry Creek below the confluence with East Twin Creek. When you said we would see at least 160 gallons per minute, is that flow we would see almost immediately, or would it take some time to see those flows?
Yeah, good question.
Objection. Compound and lack of clarification on terms, including Upper Springs, and incorrect summary of testimony.
Um,
And
Mr.
lead.
Mr. Petrozelli, what's your response?
Well, I'll ask it another way.
All right, so the objection is sustained. Please restate or reframe your question.
So, Mr. Lowe, when you said we would see at least 160 GPM, but for BlueTriton's diversions, would we see at least that amount of flow right away, or would it take some time?
Objection. Where? These questions are not clear.
Yeah, I think I'm going to sustain the objection. Mr. Petrozelli, I think you do need to specify where you're asking for him to give his opinion about these flows.
Mr. Lowe, at what point in Strawberry Creek would we see at least 160 GPM of flow?
The best indicator we have of that is when they did some trial let outs in
Objection.
1930.
Okay, Mr. Petrozelli, I don't think this has to be as hard as you're making it. I know maybe you're doing the best you can, but I'm just going to make a suggestion here that might avoid some of these objections. I think if you took it from the top to the bottom and asked questions about specific locations, it might make it a lot simpler. And the term Headwater Springs, I think Mr. Lowe has clarified but what that means. But if you're going to use the term, it'd probably be good just ask him to first, in a separate question, and clarify what he means by Headwater Springs. And then just somehow you're going to have to try to be specific as to location if you want to continue this line of questioning.
Mr. Lilly,
Yes, Ms. Doty, please go ahead.
may I suggest that perhaps pulling up one of the maps would help? There's SOS 49, which was the row map yesterday, or SOS 24, which was the Haley Aldrich reports, visuals, Google Map visuals of the location.
Okay, I'll tell you what I'm going to do. We've been going now for over an hour. We're kind of getting a little bogged down here. I know, Mr. Petrozelli, you're doing the best you can, and this is challenging. I'm going to go ahead and set our lunch break, our noon break for lunchtime until 1 p.m. So, Mr. Petrozelli, why don't you consider Ms. Doty's suggestion? It's certainly up to you how you want to ask your questions, but a map might help. And consider Ms. Grady's objections. I think she really is objecting on grounds to try to seek more clear information here, which I certainly want us to have. So let's why don't you give it some thought over the next, we'll say hour, and we'll come back at 1:10 p.m. and see if you can wrap this up. I'm not sure how relevant this is. You did give an explanation that was sufficient for me to allow you to continue this line of questioning. So give that some thought, regroup, reorganize your questions in ways that hopefully will avoid objections, and we will be back at 1:10 and we will take
Mr. Lilly?
Yes, Ms. Brady.
Ask that we go to 1:15. I apologize. I do have one personal obligation to a child.
I I certainly respect those. So let's go to 1:15. We'll be back at 1:15. Thank you all.